Hello and welcome to No Confidence. I'm your host, David Myrland. Nothing you'll hear me say is intended as legal advice of any nature. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis, believe it. This is February 14th, and today's show is a taping of an interview where I appear on Lowell Becraft's radio show on themicroeffect.com for a discussion of tax law as it's found in the Internal Revenue Code. None of it has anything to do with anything you hear in the Patriot movement, and I can't underscore that enough because there's a lot of confusion out there, and a lot of people, they simply don't get it. They don't get it. And the latest thing, as Larry points out, hey, I'll help you sell your birth certificate to a foreign bank. Well, that means you're in interstate commerce selling what the government will call fraudulent securities, worthless securities. And you go to prison for that. Just another example of the kind of trouble that the Patriot movement is good for. I've never, since 1992, when I turned my back on the Patriot movement, I've never had anything to do with those folks except trying to wake them up to the fact that the law is perfect. This is an interview. It lasts almost 2 hours. Again, it was on themicroeffect.com. I urge you to visit their website and read the articles you find there, and tune into Mr. Becraft's show there, the Liberty's Hammer. So, with no further ado, on with the interview. Thanks for tuning in to No Confidence.
And good afternoon to all of you Micro Effect listeners. This is a program I call Liberty's Hammer and Anvil. I'm the host on the show. My name's Larry Becraft. I'm sitting here in my office in Huntsville, Alabama, and as I gaze out the window, you know, this is a nice day before the storm hits. You know, here in the east over the next week, I'm told, we're going to be having some cold weather and snow. Now, I know you could probably say, well, I'm not going to listen to this program. Since we're going to have bad weather next week, I'm going to go get out and enjoy it while I can. Let me invite you to hang around and listen to this program today. You know, April 15th is just right around the corner. And a lot of Americans are going to be rushing out there to file income tax returns. Why in the world do they do that? Well, you know, they've been conditioned. You know, it's the giant brainwashing machine that washes the brains of too many Americans, and everybody, you know, they have this custom. They have this belief that they got to file these income tax returns. And if you ask any of them if they've ever really actually looked at the law, number one, they couldn't tell you that they even know the title of the Internal Revenue Code. They certainly have never looked at the Internal Revenue Code. You know, they just believe all the professionals out there. And the professionals, all the professionals do is, you know, they look at the current law. Well, you know, there's some real problems in limiting your inquiry to the current law, and we're going to be discussing some of that during the course of this program. But most of this program is going to be devoted to a discussion with a proponent of, you know, the Section 83 of the Internal Revenue Code. We have David Myrland on from Seattle. He's our guest today. He was scheduled last week to be our guest, but we had some network difficulties up there at the Micro Effect studio. And since we couldn't have him on last week, we're going to have him on this week, and we're going to be talking about, well, how in the world do you determine what income is? You know, what role does basis play in the determination of taxable income? What is the gain drive for capital labor or both combined? That's what we're going to be talking about this afternoon. And I encourage you to, if you really want to get into this, we're going to be talking about some things. Keep some notes. Get a pad of paper, get a pen, and as we go through some of this discussion, you know, when you hear something that either we tell you it's important, go look it up. You know, you'll have a little pen and piece of paper there so you can keep notes of this during the course of this program. I would also encourage you to go over to the Truth Attack website. Years ago, Tommy Cryer and I created Truth Attack, an organization that was going to try to pull together a lot of patriot groups, but unfortunately Tommy died a couple of years ago. But in the interim, we did establish the Truth Attack website. And if you go to the Truth Attack website, the law library is, I'll tell you this, I put everything that you find in the law library on Truth Attack is stuff that I put up there. But one of the things you will find in the Truth Attack law library, there's a file called Primary Sources of Law. And, back in the late 90s and the early 2000s, I was busy, one of my little projects that I was carrying out was making the statutes at large available to people. And so I took these files of the statutes at large and strung them together and created, you can go over the Truth Act website and download whole volumes of the United States statutes at large, and it's all word searchable. But also in that same file, Primary Sources of Law, you're going to see the results of another project I carried out, finished 12 or 13 years ago. I made available all of the old tax acts and all the old tax regulations. And right below the statutes at large, you will see, you can download PDF images of, the 1918 Revenue Act, the Revenue Act 1921. They're all word searchable. Plus, we scanned the regulations for each of those acts. And guess what? Those files are also word searchable. So you have the statutes at large, the whole volumes, or, not everything. I did a lot of the volumes, when we got to the private acts, the private acts are useless. I didn't do the treaties, but, the public acts of the statutes at large are posted there on the Truth Attack website. And you have the old tax acts and the regulations. And I encourage everybody to become familiar with it. So with that in mind, that you have all these resources available, and with it being, please remember, we're going to be talking taxes today, and that's one place where you can go get it. Now let's just bring on our guest, David Myrland. David, are you with us?
Hi, Larry. Can you hear me now?
I can. I'm sure the audience can too, our listeners.
You're coming through loud and clear too.
Well, good. It's a whole lot different from last week, wasn't it?
That's right.
Hey, David, for the benefit of our audience, our listeners, can you give a little bit of background on yourself?
Sure. In 1988, having made $1.5 million worth of drinks here in Washington State at high speed with the band plan, I thrived on the pressure of high volume bartending, and I was extremely proficient at it, making upwards of $1,100 worth of drinks per hour on Friday and Saturday nights.
Wow.
At 1986 prices. I'm 6'3", wiry, and my hands are huge, and my memory is incredible, and I was made for high volume bartending. And in 1988, right around April 15th, that means a couple months, we're going to have 27 years, the IRS came to my door and made me angry. I didn't like the way I was treated, and with a bartender's memory, I recalled that at the door, on the doorstep, they said in 1984, when you filed your tax return, you didn't claim your tips, and so you owe us like $4,200. And if you do the math, that means I made a boatload in tips. And as a high-volume bartender, I was right in the thick of things in the downtown lounge in Bellevue, Washington, Bill Gates' city, and had the richest and largest clientele and bartender's attitude, where if you give me any guff, I'll just pick up the phone and have you bounce, And I remember the IRS telling me that your tips are 61A gross income. And I, of course, remembered that number. I have a near photographic memory. And I scheduled a meeting. I said, we'll sit down and talk about this. I got a lot of things going for me right now, and I'll pay it, and we'll all move on. And the IRS agent said, okay then. And I scheduled a meeting for 3 weeks out. And a couple days before the meeting, I called, can't make it, and let's reschedule. 3 weeks out. Right before that meeting, I called, rescheduled, 3 weeks out. And right before the next meeting, I found another job, moved away, and started studying tax law in June of 1988. Several years later, I made a few appearances as an expert witness on the tax code because for several years I dove into the tax code all the way. And mostly because the first place I went, I found a lie. They said your wages are, your tips are 61A gross income, and you got to report those. And so the first place I went when I finally found a tax code, I'd never looked at a statute in my life, I find 6053 that says you have to report tips to your employer. And it lists every kind of tips except 61A tips. It refers to tips in other chapters. So the first place I went, I found a lie, and that got me going. And so I kept poring over the tax code for 2 or 3 hours a day after I would work for somebody else all day. And then the breakthrough really came in 1992 in August when I left employee status behind and became self-employed as a taxpayer advocate, where I could now do tax law 10 hours a day. And it was then that all my acquired knowledge from my previous research organized itself right in front of me, and I came to understand certain things about the tax code that still nobody is teaching. And the volume of research I did led me into different areas of the tax code that anyone else argues. And when I point to a couple of key conclusions of mine that I've fully briefed and pressed against the government in and out of court, understand what I teach is only a 1/75th or 1/100th of what I actually learned about the tax code and the IRS over these years of research and advocacy. And, you know, you'll learn things about the IRS that don't amount to a controversy, and then you'll learn things that amount to a huge controversy, and everywhere in between. So I don't need to teach you everything I know about the tax code, but when I wrote my 1994 treatise on the differences between the tax code and the IRS, I did so from the standpoint of, okay, I'm a citizen of the United States, just like you say I am. Servant breath. And when I claim to be a citizen of the United States, a world of protections opens up to me. There's a certain structure to the tax code that honors a limited federal government. It honors property rights. All property is a cost. And it honors voluntary compliance. But I base all these arguments on statutes. And I don't argue citizenship unless I'm going to point to my citizenship, which I'm a U.S. citizen according to them. I start with that premise. I traverse into what they say, and then I've got tools to protect me lying all about me. So by 1998 October term, I had petitioned the Supreme Court 5 times, meaning I wrote for people who needed tax help, and basically proved that tax law is futile as far as litigation goes. And I want to underscore the importance of doing what you suggested at the beginning of the show: get a pad and a pen and write down some of the things that I'm going to tell you. And I'll let you catch up, go out, get a pen and a pad, and in a minute I'll give you my website, I'll give you an email address, a couple other things. So I gravitated in the late 90s to state law, of course, motor vehicle code, and was fortunate enough to meet somebody with their feet on the ground regarding what tools are available, which is state constitution, state statute, the motor vehicle code, traffic court rules, and nothing relating to anything that the Patriot Movement or Freedom Movement teaches about anything. He was in the box, and he had bodies of prosecutors lying all over the state. His name is Kurt Riggin, and he's a criminal procedural expert and tribal lawyer for several federally recognized tribes. So I was very fortunate to meet somebody that would keep me totally directed at the law, in the box, pleading. And in 2005, I warmed up my tax work because the IRS penalized me for promoting abusive tax shelters. And this is like May and July. 2 times they penalized me 1 penny and then paid the penny for me, so the penalty was 0. And I knew they don't do anything like that on accident. And I reasoned that they wanted to go to a grand jury later and say, you know, we penalized him twice and he didn't even complain.
Yeah.
And I didn't want to remain somebody who had failed to complain. So I rebriefed my treatise on several key findings on the differences between the tax code and the IRS. I put a 33-page extortion and racketeering criminal complaint on top of the memorandum, a 12-page cover letter with the 2 one-penny penalties attached to it as exhibits. All this is sworn testimony. It's notarized. And then a few exhibits behind the memorandum, table of authority, certificate of service to nearly 80 members of Congress, and shipped it off, 180 pages on December 28th of 05. We'll call it New Year's of 06. Cost me almost $6,000 to do all this.
Wow.
To pay the notary, to pay all the photocopying. And I served it on everybody in the Joint Committee on Taxation. Tax Code Section 8022 says they're in charge. I served everybody on the House Judiciary Committee and everybody on the Committee for Government Reform and Ron Paul. And I've never received so much as a punctuation mark back. A carbon copy went to the Secretary of the Treasury and one to the Commissioner of IRS and one to the then U.S. Attorney General. I think it was Albert Gonzalez. And bring it up to date. Since 2006, my business partner and I, his name is Chris Chapman, he and I have used that treatise to prevent more than a dozen indictments. We've seen IRS criminal investigations shut down and grand jury proceedings shut down when these findings, this briefing, this complaint to Congress is injected into the mix. And it takes the shape, my victories don't take the shape of an acquittal. And for these people out there that say, hey, we won. I'm Bernice Kuglin, I'm Lloyd Long, I'm John Cheek, and we won. Well, you were still indicted. You still were arrested, fingerprinted. You might be held pending trial in custody, and you still had you spent thousands of dollars on an attorney, or you got saddled with a public defender, and your life was in the hands of strangers in the form of a trial jury. Whereas my victories take place like this. Hey, my relatives are subpoenaed to appear before the grand jury and testify about my business, how much money I make, how I spend my money, and what can you do? And we help them understand a couple of key arguments, and if they, after coming to know these arguments, feel that indeed crime is being committed by the Internal Revenue Service, we can help them become a co-complainant to the 2006 complaint by filing an affidavit of joinder saying, I read the complaint, I've read the memorandum, I think I'm being deprived of Section 83, and they're conspiring against my rights, it's a felony, and I'm here to report crime to Congress. Then they take that affidavit of joinder with certificate of service and my criminal complaint and memorandum and serve it on the Department of Justice. And they have closed down the grand jury proceedings at that point. So no docket number was ever established for me to point to. But getting back to what is a victory, you were indicted, you were taken before a trial jury, you spent thousands of dollars, and they say they won. I call that a close call compared to being able to shut down a grand jury where you don't even get dirt on your knees.
Yeah, not getting indicted is real important. Hey, David, let me stop you right here. During the course of this show so far, you mentioned this this complaint, this 2006 complaint? What in the world is that?
Under Title 18, Section 4, if I know of felonies committed by anybody under the laws of the United States, I'm required to report it to some judge or other person in civilian or military authority. They can't refute that they're stealing. And so I better report these crimes. And what led me to this was those 2 one-penny penalties, but also in March of 2005, I get a phone call from a gentleman in Texas, and he says, I don't know you, I just heard your name from a friend of mine. He says, you do dynamite work. I think I might be indicted for failure to file. I said, how would you like this is the first thing I said. I said, how would you like an exhibit that proves you sued the United States for proof that the tax code applies to Americans, and they can't even debate you on 3 or 4 statutes? He says, let's go for it. So I wrote a civil action under Rule 27, action to perpetuate testimony. All it does is open up a docket number to allow you discovery, and supplied a 3-issue brief, a 3-argument brief behind the complaint, saying all I want out of this civil action is for them to either agree that these 3 conclusions are correct, or if they say it's wrong, I want them to answer the questions presented for review about those conclusions. 3, 4, and 5 questions, a total of 12 questions. Issues A, B, and C, 3, 4, and 5 questions. And instead of answering the questions to prove the conclusions were invalid, U.S. Attorney Stephen Bass, Assistant U.S. Attorney Stephen Bass, asked for a protective order against the questions, and U.S. District Judge Lee Yeakel issued the protective order against asking the government those questions about those conclusions. And so that was exhibit number 1 in my congressional filing. And I didn't want to be somebody who failed to complain. I wanted to put a great big stack of laundry in one place to where if they ever mentioned the Internal Revenue Code to me again, I could hit them with a great big stack of laundry that I knew Congress couldn't refute. The DOJ can't refute, the IRS can't refute, and these are very basic statutory arguments. My protections are everywhere in the tax code. Now, August 27th of 2014, I filed a supplemental memorandum to bring my 2006 complaint up to speed. I've got a couple more authorities in there that had not occurred or been written before my 2006 complaint, one of which, Goodmanson versus the United States. Now, get ready to write, everybody, because all this is on my website. Goodmanson versus the United States, Second Circuit, that's 1 level below the Supreme Court, says, quote, at the heart of this case is Internal Revenue Code Section 83, which governs the taxation of property transferred in connection with the performance of services, end quote. So you got a statute that explains how to tax all compensation.
Well, hey, David, we're going to get into the meat of it right now. Before we get into the meat of your argument, I want to back up a little bit.
Okay.
You've studied the code. What is your opinion about whether or not the average American can sit down, devote a little time to it, and comprehend and understand the tax laws?
My understanding began with the notion that I should ignore everybody else and read just the tax code.
Wow! Great.
But I did that after learning a whole bunch of other stuff that people were teaching, and I was fortunate enough to begin with curriculum from the Golden Mean Society in Condon, Montana. Peggy Christensen headed that up. And it was based on statute. And it wasn't on non-resident alien. None of that was in any of that work. And so it wasn't based on limited federal government. It was all based on trying to crack what are the meaning of particular statutes. So I had a start that was very well founded, and I owe that group my proper beginning to analyze tax law. So I stayed with that. And then there was the Fifth Amendment argument against providing information on a tax return that could be used against you in the future. But they were heavy on statute. And so when I turned off the Patriot movement in 1992, because all I saw were 1040 NR frivolous filing penalties all around me, I went back and started reading at page 1. And when I reached certain statutes, I saw that these statutes indeed operate, like Section 1 imposes the graduated income tax. Section 3, the earned income tax credit, I think it is. Section 31A, you can get credit for what your employer takes all year from your paycheck against your year-end liability. And Section 61A, gross income, means all income from whatever source derived, including but not limited to the following items. And then they go, fees, tips, commissions, salaries, alimony, dividends, gains derived from dealing with property. Basically, it's the burden of proof statute that says everything's gross income except as otherwise provided. They give you one option. You have to find where it's provided before you get a deduction for it. And that's the one that puts the burden of proof on the individual or the corporation, is that everything is gross income unless you can prove a deduction is provided. Provided, that means it has to be in statute. And there are certain provisions that provide. You got 163, I can deduct interest that I pay on my mortgage. 162, if I have a home business, I can deduct the cost of paying my employees. Section 212, in the case of an individual, there shall be allowed as a deduction all ordinary and necessary expenses paid or incurred in the production or collection of income. But then I came to Section 83 and I said, this is otherwise provided, and if it applies to me, it's not being enforced, because it says only the excess over the amount paid is gross income. And I've been including the whole paycheck in gross income all this time. And so I shut down everything at the office and went to the law library and looked up probably in the neighborhood of 80 cases on Section 83, and I found, and they're on my website, get ready to write, everybody, I found a handful of cases, including tax court and circuit courts, that say Section 83 applies to all compensation for services. It explains how to tax it, and yet the IRS doesn't train on it. This is the first I had heard about it because I was studying everybody else's work, and still, to this day, nobody's teaching it. Here's my web address, wevgov.com, like Roe v. Wade, wevgov.com. That's we the people versus government.
Hey, Dave, I sent out an announcement about this show today, and I had a link in there, and you got a copy of that. Are you saying that I sent out the wrong link to your website?
Okay, that's a blog that I had set up, and I don't maintain that blog site at all. And that's okay, because here I am on the show, and in person people can see that it's wevgov.com. Yeah. So we'll get over that, and we're going to have a break here in just a second.
So my guest this afternoon is David Myrland. We're talking about what is income. We're ultimately going to get around to that type of discussion. But before I start asking questions again of David, I want to make a few points. Of late, I've seen a lot of stuff. I've been receiving, information about what other people are doing by means of email. Here this last week, I saw somebody, he used to be associated with Tim Turner. He's been doing some mortgage foreclosure battles. He came out with a new proposition this week. Gee, everybody knows you can sell your birth certificate. Boy, if there isn't a greater scam, a lie, is everything that floats around the freedom movement about birth certificates. Birth certificates just memorialize a fact that you were born here. The party identified that the birth certificate was born in this country. It is the document we use to prove that we are citizens of this country. That's all a birth certificate is. It has no commercial value. Your birth certificates are not sold on some stock exchange. They have no monetary value. However, this guy was promoting this program. You send him $250, And he's been able to locate some bank in some foreign country that's going to be buying all of these birth certificates for millions and millions and millions of dollars. Let me just tell you, ladies and gentlemen, that is a scam. Now, remember, this is my recollection of the website. It's Monetize, COLB, standing for Certificate of Live Birth. You can do a search for that. You'll come up on that website. Let me just tell you, ladies and gentlemen, that's just another scam that flows through the Patriot movement. Now, having said that, I want to return to our conversation regarding what is income. Hey, David.
Yes, I'm here.
When you started, back in the late 80s, when you started looking into this, you told us that you'd never even taken a look at some statutes before, but you ultimately found out that there was this thing known as the Internal Revenue Code, Title 26, and you made the statement that you had never taken a look at any type of legal material before. And then you started reading cases. Would you agree that, for somebody that's interested in learning about it, you can learn about it? It may be kind of technical in the spot, but soon you're going to get to the spot where you can reach comprehension and understanding about the statutes and regulations and the cases. Is that a fair statement?
Yeah, I wish there were free seminars out there for everybody. Well, I got news for you. Everybody. A case, a decision in a law book that you go into a law library and you got shelf upon shelf upon shelf of volumes of volumes of volumes of written decisions from judges. Every one of those is a seminar from a judge.
Right.
Free. Go get it.
Yeah.
And listen, in 1995, I think it was, you had the case of U.S. versus Lopez. Here's how I took on that case because I had a certain question. U.S. versus Lopez was a San Antonio youth who took a gun to school, and under the Safe School Zone Act, the Fed picked up the case and prosecuted him, and all the way to the U.S. Supreme Court. He lost in district court. He was convicted, but then the appellate court, I think, and the Supreme Court definitely ruled that it wasn't an act that substantially affected interstate commerce, and therefore it was outside of congressional jurisdiction to prohibit a youth from bringing a gun to school. And I took that case because I took on reading that case to learn more about the limits of Congress under the Commerce Clause. So I read that case, and then I went and got a photocopy. I was in the Stone Age. I went and got a photocopy of every case that was cited in U.S. versus Lopez, and I read every one of those. And some of those, I went and got photocopies of cases that were cited in those cases and read those cases. So I got upwards of probably 35 seminars on the Commerce Clause directly from judges, mostly on the appellate and Supreme Court levels. So that's what I use case law for. If I got a question at law, I want to go see how the judges are doing. Now, there's a case that came out January 12th, that was last month, about filing false and fictitious liens on federal public servants, 18 U.S.C. 1521.
Was it a criminal prosecution?
Yes, it was a criminal.
It sounds like it's an appeal to somebody that's been convicted for doing that, right?
Well, it was an appellate decision, and what had happened was the guy filed liens, but the liens didn't identify any real or personal property of a public servant, and one of the essential elements of the statute is if you lien real or personal property belonging to the public servant. And so he didn't meet one of those elements, and I read the Ninth Circuit decision, and I saw they disposed of that element. So basically, if I lien my own personal toenail clipping, I'm guilty under that statute. So sometimes, not every time, will the judges play the straight and narrow. But, and this is a good instance, a real easily recognizable instance of judicial misconduct, legislating from the bench. They disposed of an essential element of a criminal statute to keep a guy in prison. He's in there for armed robbery, and a person I know who's been indicted for filing false liens came to me with the indictment saying, you know, I did something really stupid, and I told him to call the lawyer that handled that appeal and learn which way the grass lays. And the lawyer told him that sometimes when I talk to this client, it seems like he's on planet Earth, and other times he's not.
Oh, yeah.
And so the judges
there's
felt
a lot
free.
of people like that.
Sure, but the judges felt free to say this guy ought to be in prison more than he is right now, so we're going to go ahead and give him 87 months for filing these false liens, when in fact all he named as collateral in the liens was oaths and bonds, and the judges are not bond. I'm sorry, it was against prison personnel. It wasn't against the judge. And the oaths belong to the government. They aren't the real or personal property of the public servant. So they skirted that element of the offense and said, doesn't matter if he named property or not. We're the Ninth Circuit, and we know better than Congress. So sometimes judges will reach out and really screw with Congress, but the rest of the time, really, it's a great source of knowledge to read case law. And in the first few years, I was on a solid diet of case law, and by this point in time now, I've read easily over 4,000 decisions. And this is how I view cases, as a seminar from a judge. It's a roadmap for American jurisprudence.
Right. Hey, David, let me stop you right there. For the benefit of our listeners, I invite you to go over to the Truth Channel website and download all the old tax acts. Here's the reason why I do that. And last night, to prepare for the show, to give some information to our listeners, I sent out a document. It strings together, sections out of the old tax acts. And the reason I did that is to show something that shows up in the tax laws. In 1913, October 1913, after the 16th Amendment was allegedly ratified, Congress came along and passed the first income tax under the 16th Amendment. In early 1916, the Bruce Shaver case came out. In October 1916, they came along and they repealed the 1913 Act, and they imposed a new tax in 1916, and that was amended in 1917. But starting in 1918, you see the pattern. And this is a pattern that manifests itself, shows up in a lot of tax acts of Congress. It's what I call the in lieu of feature. In 1918, Congress came along and said, well, in lieu of the tax imposed by 1916 and 1917 income tax acts, we impose this tax. Then 1921 comes along. Well, in lieu of the previous tax in 1918, we impose this tax. 1924 comes along. Oh, in lieu of the 1921 tax, which is in lieu of the 1918 tax, we impose this tax. And that's the way it's all in lieu of, all the way up to 1938. So if you were sitting in 1938, if you were sitting there taking a look at the income tax, the 1938 tax was imposed the 1936 tax, and the 36 tax was imposed in lieu of the 1934 tax, and 34 was imposed in lieu of the 32 tax. 32 was in lieu of 28, 28 was in lieu of 26, 26 was in lieu of 24, 24 was in lieu of 21, 21 was in lieu of the tax imposed by the Revenue Act of 1918. So it's all interconnected, and the same, who's subject to the tax and what is subject to the tax remains the same through all the tax acts. But the reason why they do this in lieu of feature is, they make changes over time for the purpose of, misleading people, for, getting you to forget the history. And there's an old adage that's been around for years. If you don't know history, you're doomed to repeat it. Well, the same thing applies to the income tax. If you don't know the history behind it, hey, you're not going to be able to see the real truth. Now, in 1938, they wanted to codify. They wanted, since you had all these tax acts that were scattered throughout the entire United States statutes at large, there was an estate tax imposed, let's say in 1928, and there was a tax on white phosphorus matches, and there was a tax on estates and gifts, and, they were scattered throughout the statutes at large. So what they wanted to do is they wanted to stick all the acts in one act of Congress, and thereafter all they had to do is amend that one tax of Congress. So in 1939, they codified. They passed a law to stick all of the old tax acts, all the existing tax acts, into one law. That was the Internal Revenue Code in 1939, and the provisions for the income tax came straight out of the 1938 Act. 1954 comes along, and all it does is it reshuffles the codification of 1939. 1986 code, when you go back to the law that deals with, we call it the 1986 Internal Revenue Code right now. When you go back to that law, look at that law, and it just simply says, the 1954 Internal Revenue Code, its name is hereby changed to the 1986 Code. So the 86 Code is nothing more than the renamed 1954 Code, the way it looked in 1986. The 1954 Internal Revenue Code is nothing more than a reshuffling of the codification of the tax laws that had happened in 1939. The 1939 Code simply took the income tax provisions of the 1938 Act, since they were the existing tax laws regarding the income tax at that time. The 1938 Act just went straight into the 1939 Internal Revenue Code. Well, so the Internal Revenue Code of 1939 had the 1938 Act in it. Well, the 38 Act, as I said a minute ago, was in lieu of 36, in lieu of 34, in lieu of 32, in lieu of 28, in lieu of 26, in lieu of 24, in lieu of 21, in lieu of Revenue Act of 1918, which imposed the tax in lieu of the Revenue Act of 1916 and 1917. So all of this is interrelated. Now, we're going to be getting into, in this discussion of income tax, we're going to be dealing with some of these older definitions of income. Now, David, now that I've covered one point I wanted to cover this afternoon regarding that matter, I want to cover later on, what the tax laws have said in the way of statutory definition of gross income. But, that's something I wanted to cover. Now let's pick up with where you were. You were saying a minute ago that studying the cases is real important. Now let's shift around to income. The Supreme Court, the basic, the Supreme Court's come along and, people have challenged, what does 16th Amendment mean? What does income mean? And basically the decision of the Supreme Court is that income is, Eisner versus McComber, is the gain derived from capital, labor, or both combined. Now, it seems like to me, where you are in your arguments about Section 83, that's an important principle of your argument. Am I correct?
Oh, yes. Especially in relation to what is and is not gain. The word gain is profit.
Right.
The word profit is income. The income tax is a profit tax. I don't make all the other arguments that you've heard in the movie. Oh, it's an excise. Oh, you're a federal employee. Or you accepted a benefit fee. Oh, excuse me. The law has to operate to impose the tax, not some presumption that enforcement is legitimate and therefore the law must be in a certain shape. People, and I'm telling you, this is so widespread, most of the movement is based on a presumption that enforcement is legitimate. I must have assessed myself. I must have used the zip code. I must have, spare me.
Yeah.
Instead of saying must have, why don't you get to the law and see whether or not the government is violating the law? Now, income is not defined in the code. Hogwash. Income is profit. Cost defines profit. And cost is defined in the code. And you don't know this until you realize Section 83 applies to all compensation. It explains how to tax it. Only after Section 83 has operated can you mention 61A gross income. So everybody starts on a false premise that the IRS gave them. All the accountants, all the taxpayer advocacy organizations, H&R Block, Ronnie Deutsch, all the rest of them, they start with the premise that we are in 61A and except as otherwise provided, everything's gross income. You have to start in Section 83 or you lose Section 83. And all the case law says it's where you start. And this is on the federal income taxation page of wevgov.com. There's the only thing on this website are things you have to know. There's nothing extra. And yet, if I have the definition of income, it's called 83A. If, in connection with the performance of services, property is transferred, the excess or the value of that property over the amount paid shall be included in gross income. And under Section 83, regulations define the amount paid as the value of any money or property that you paid. I've taken this to the limit. So we don't need to guess about any of this, and none of this is legal advice. Okay? I'm not here to give you legal advice. I'm never speaking to give you legal advice. And these people that say, hey, sell your birth certificate, this comes from a total lack of knowledge of who their foe really is. You have a government that said at one point in time, we're going to steal from hundreds of millions of gun owners. If they're willing to do that, do you think they'll let you get away with one penny? I'll bet you they did monetize my birth certificate. I'll bet they did. There's nothing they won't do. But when it comes to being upheld as legitimate, you're going down for peddling false securities if you try to sell a birth certificate as a security. So back to the law. 83 defines income. It says only the excess over the amount paid is gross income. And so we have to determine what the amount paid is. Regulation 1.83-3G says the amount paid is the value of any money or property paid for the paycheck. Any is an all-inclusive term. And the only method of interpretation they resort to say, oh, you can't do that with labor, is they say, you didn't buy your labor before you sold it, so when you sell it, everything is a profit. That's their only out in 5 trips to the Supreme Court by October of '88. The only way they disposed of the argument was to say, you didn't pay for your labor before you sold it, and so you can't include it in cost or amount paid. And my challenge was always, where's your authority to exclude labor for any reason from the term any money or property? And they can't cite a law that allows for it.
Yeah, hey, David, it's an invention on their part. You know, Tommy and I used to talk about this at great length, and they just go to the. I think there's a tax law case.
Well, I know, but I was at the end of this description here.
Okay.
Okay.
Go ahead.
They look at the term any money or property, and they arbitrarily. They do it without a law that allows them to exclude labor, and they simply do it. That's a policy. And there's 4 Supreme Court cases that the government won in 1987, 1992, like 1999 and 2002, where the government argues the term any is all-inclusive, and you have to have a law that creates an exception to the term any or any property. So the government was winning, arguing about the term any property the same way I was arguing and losing. So now I fortified the argument to show the only way they get out of treating labor as a cost is arbitrary. It's a policy, not a statute that allows them to. So I've got the argument refined, and the results are in to this degree. It's a fight over the interpretation of any money or property, and I got 4 Supreme Court cases on my side, and the January 12th decision over leaning federal public servants cites one of those cases on the 9th Circuit here in this opinion as any is all-inclusive. So I'm building my, you'll see it at the bottom of the federal income taxation page on wevgov.com. So I have it narrowed down to exactly that. They're misinterpreting the term any property impermissibly because it's arbitrary. And so back to the point, 83 is the definition of income. The government doesn't even train on it, and there's no accountants out there that know anything about it. I should add, one of the co-complainants with me to Congress in January 1st of '06. In 1973, he became a self-employed accountant and enrolled agent to the IRS, meaning he could represent you or me at audits or in tax court, and took yearly courses so he could maintain his certification as such. He co-complained with me after verifying my entire treatise. So I have an IRS enrolled agent of over 30 years co-complaining with me to 80 members of Congress on that criminal complaint. Go ahead.
Well, I just want to interrupt right now. We're getting ready to, the Internal Revenue Code, the income tax section of it, there is at least some organization to it. And what we're talking about here in reference to organization is, we're focusing in on subchapter B. and which starts off with Section 61. But then, a different part under Subchapter B, that you're talking about is the items that are specifically included in income, and then there's a set of sections that are items specifically excluded from income. And Section 83 is in that section, that part, that's where the sections are all dealing with items specifically excluded from income. Now, to me, your argument is that when you come up with a gross receipts, you've got to utilize the basis rules, starting off in Section 1001. If you buy a car for $5,000 and you hold it a week and you work on it a little bit, and you find somebody to sell it to the next week for $7,000, the $7,000 represents your gross receipts. And since you bought the car, you're entitled to subtract off your basis in that, which would be the $5,000 that you paid for the car. And let's say that you spent $150 polishing it up and other things. That's another cost. So you get to take out of the gross receipts the basis. And folks, we'll be back. We've ended 1 hour. We got another hour to go. Discussing income today with David Myrland. Now, here's what I like about David Myrland. On September the 10th of 2011, I was coming back from Milwaukee, flew into Nashville. I'm glad I got out of Milwaukee. Bob Schultz went on September the 10th. He went out to Phoenix to visit with Irwin Schiff. Well, I made it home before September the 11th, but Bob Schultz didn't. He got marooned out there in Las Vegas. Spent a week with Irwin Schiff. Now, wouldn't that be fun? But one of the things that we had done over the prior month, Jeff Dickstein, Bob Bernhoff, and I, we put together 300 questions that Bob Schultz wanted to ask of the IRS. One set of questions in that long list of 300 questions involved this very argument that we're talking about here with David Myrland. Now, David has come along, and he's done something that a lot of people simply do not do. I know that a lot of people are busy, but if you're going to be interested in the tax issue, I think you really need to sit down and look at it and understand it. And that's exactly what David has done. He has, he's making popular again the an argument that's been involved in the movement for a long time. Let's deal with basis. And he's got some tools that he's utilizing. And that, I think, is real important for people to, have a guest on this program that explains exactly what he's doing to show to others, what somebody else is doing to move forward on this tax battle. Now, right before the break, David, I was talking about basis. You also utilize the basis rules as part of your argument. Am I correct?
Yes, but first things first, are you having fun?
I didn't hear you. What?
Are you having fun?
Well, I like to have fun on these radio programs, but I'm having fun right now.
Good. So am I. The basis rules. And I reminded everybody to get a pad and pen, just like you told them. You write this down. 1939 Tax Code, Section 111, 112, and 113. 1939 Tax Code, Section 111, 112, and 113. Those in the 1954 reshuffling for the new tax code then became Sections 1001, 1011, and 1012. That's 1001, 1011, 1012. Regulations under Section 83, Regulation 1.83-4B2 says to figure your costs, apply Section 1012. So there's my tie for Section 83 back to the 1939 tax code and the standard for computing cost. And
now,
2012.
Let's deal with the concept right here first. Right before the break, I was talking about the sale of the car. You get the gross receipts from the sale of the car, then you get to subtract off your basis, your investment in it, and any other costs you have involved in it. And in that previous illustration, we had a $5,000 basis, and I think we spent $150 to clean it up, and then we sold it for $7,000. Under those circumstances, you get to deduct $51.50 from the $7,000 figure to arrive at your quote gross income, and that is the gain derived from the conduct of a business of selling cars. Now, isn't there a direct parallel in reference to labor?
Yes, but it starts here with a consideration that the car was sold to an unrelated party who's a willing buyer and you're a willing seller under no compulsion to buy or sell, all relevant facts disclosed. That's an arm's length transaction. An arm's length transaction establishes the fair market value of property. If it's sold in an arm's length transaction, that is the value of the car now. And then you take into consideration, is part of the sale, the labor I put into this. You bet it is. Because when I bought it, this fender was dented, the carpet was torn up. I fixed all that. Well, that's labor. And so the benefit over the price you paid for the car that you ultimately received for the car is from an unrelated party in an arm's length transaction for the labor you invested. And so that increase in the value of the car is compensation for services.
Well, I want to talk about that later on because there's an area that you and I have a disagreement on, but I won't explain it as we get further down the road. But go ahead.
Well, labor is property, and as I stated, regulations under Section 83 say apply 1012. 1012 says basis of property. The basis of property you buy is usually its cost. Okay? And the first regulation under 1012, 1.1012-1A, says your cost is cash or other property. Labor is property, and there's no exclusion of labor in that language.
Right.
So I include labor in cost under that statute. 1011 says the basis in 1012 could also be known as adjusted basis. That's all it does. It assigns a synonym. 1001 tells you what to do with that adjusted basis. Regulation 1.1001-1A says the value of property is normally its cost. Rarely will any property have no fair market value. The standard, and I haven't read this regulation in a long time, you can tell, for calculating cost is that you calculate the adjusted basis from 2011, and what remains, it must be restored to the taxpayer, and what it remains constitutes the realized gain. You can't deduct the labor. You have to deduct the value of. And so I take the dollar amount that's attributed to my labor, and I therefore would deduct it. And none of this is legal advice. The only reason I have success in a criminal case or a grand jury proceeding, before a criminal case is started, is because in a criminal case, there's a conscience present called a jury or a grand jury. They are not hell-bent on racketeering and extortion like public servants are. So in a civil matter where they're just after your money and there's no jury to constrain them, they'll get your money. And so I don't file 83 tax returns. I don't do any of that. But on the criminal side, you can bet I'm going to rely on the law because I know ultimately either a grand jury or a trial jury is going to have my fate, and I want to be on record with a statutory reliance. So
right.
I have 1012, 1011, and 1001 in that order to determine my cost and what constitutes the realized gain. Now I go to 61A, and not before.
Well, let me put together the schematic of your argument. It still boils down to, for our listeners, that illustration of the sale of some piece of real tangible property, like the car. You buy the car, you get gross receipts from the sale of the car. You still get to subtract it off. And what you're saying is that you have this, there's still another cost involved. If you go out and you sell your labor to your employer, you have a basis in that. This is the thrust of your argument, am I correct?
Right. They say you don't have a basis because we exclude labor because you didn't buy it before you sold it. But the regulation says any money or property is a cost, and under Section 1012 it says cash or other property. Labor's property. You have to consider it unless the law allows you to exclude it, and they don't have a law that can point to.
And when you have something that you need to determine the market, the value of it, you know, when you can go out on the open market and see what an item is being sold for, then that can be a basis. Am I correct?
Sure. In Seattle, as a welder at Todd's Shipyard, I might make $25 an hour. But if I'm a welder on the Alyeska pipeline, freezing them off up in the middle of Alaska, I'm going to make $55, maybe $100 an hour to be a welder up there. The market has set the price.
Right.
If I got to leave my family, you got to pay me more. I'll work in the middle of the snow.
Okay, David, let me stop there. Okay, let's take that as you're a welder on you're working up in Alaska for a company, and you're getting paid $75 an hour to do the welding. You determine the basis for your labor from your contract with the company.
My contract value is my contract value is the fair market value. They're the same thing.
Right. So even though you're being paid $75 an hour, that very same transaction determined your basis. So if you're selling if you're getting $75 an hour, what did you surrender? Well, you surrendered. You're using the very same transaction to determine the basis for your labor.
And the first consideration is, did I make the contract with an unrelated party acting in their own best interest under no compulsion to buy or sell, all relevant facts disclosed?
And
yes.
That's a given. That's obvious.
Right. But you have to start there, and so since it was an unrelated party, we know what they paid me is the fair market value of the property I gave them, which is my labor. And it includes my pension, my company parking spot, the company car, tips, it includes vacation pay, my sick pay, all the rest of it that comes within the contract is property transferred in connection with the performance of services, which is the name of Section 83.
So how would you, can you summarize your whole argument in a few sentences? Without being technical. The reason I want to do that is, there's some people who are being introduced to this concept, for the very first time, and so I want to keep it kind of basic, kind of lead them through a basic explanation.
Sure. Section 83 applies to all compensation. It explains how to tax it. All the case law is right there at the bottom of the federal income taxation page of WeVGov. This means you don't have a choice. I don't have a choice. The IRS doesn't have a choice. The DOJ doesn't have a choice. And the courts don't have a choice. They have to go through Section 83 before they can mention the term gross income. And forget the fact that I have an interpretation about it. It's one paragraph, 83A. You go do it, and you tell me why you owe a tax on your compensation, because ignorance of the law is no excuse. It's just one paragraph, American. Now, take that and understand. And this you won't learn from anybody else because nobody else knows about Section 83 and has thought to apply it this way. If it applies to all compensation, it applies to wages and tips in Chapter 21, FICA. Social Security is an income tax.
Right.
And they deprive you of Section 83 to charge you to bill you for Social Security also, because 3121A wages and 3121Q tips are compensation for services, and 83 applies. Go to Chapter 2, Social Security self-employed. Self-employment earnings. Those are that's compensation for services. 83 applies because Social Security is an income tax. So you deprive me of Section 83 in Chapter 1 with a graduated income tax, and you deprive me of Section 83 in Chapters 2 and 21 when you billed me for Social Security. What were you thinking? This is a pattern of extortion and racketeering, and every IRS agent can be arrested yesterday if people would wake up to the fact they have the right to arrest a felon. Now, you deprive me of Section 83. 83 says only the excess over the amount paid is gross income. The amount paid is defined as the value of any money or property that I paid. Any is all-inclusive, and they can't find a law that allows them to exclude labor. Checkmate. You're a racketeer, you're an extortionist, you're stealing money from me on a daily basis and everybody else we see, so you better keep your pen in your pants and forget about assessing me, because all I'm going to talk about from here on out is Section 83 and when would be a convenient time to arrest you.
Okay. Now, hey, David, you and I have been talking over the last couple of months, and I've seen that you and I have a little bit difference of an opinion on some of this stuff. You say that the IRS is not taking into consideration Section 83, and I have a little bit of a difference of opinion, and I'd kind of like to lead you through this if I could. I'm saying that, well, there's a possibility that they are taking Section 83 into consideration, at least insofar as what they publish, in hard material like the statutes and regulations. You're probably right that they all, don't. When they implement the law and they come after you for some tax, this is out of the picture. But at least, if you take a look at something like the regulations, is there a possibility that this is already taken into consideration? That's where I'd like to go with this. So let me direct our listeners to, last night I sent out another file that had all of the prior tax acts, statutory definitions of gross income. Now, David, I don't know whether you've got that. Could you pull that up? Are you in front of your computer?
Yeah, and I went through it last night.
Okay, all right. Now, when the typical, all the way up through 1939, in fact, it didn't change until 1954, but all the way up through, when you sit down and you take a look at the statutory definitions of gross income from the old tax acts, they use the words, the income derived from salaries, wages, or compensation for personal services. We can eliminate, let's just focus in on that. Would you agree, there's a rule of statutory construction that every word in a law has its own specific meaning, so yes. They don't come out and, they use economy of words. Every word has to be taken into consideration because, it's included by the legislature in the specific law. So when you get down to salaries, wages, or compensation for personal services, using the standard rules of statutory constructions, when you're taking a look at these old definitions of gross income, would you agree that in this context, salaries is different from wages?
I thought about this at length. I have a real cute exercise to bring this point out.
Okay, good.
You have steam in the form of water. You have peanut butter in the form of raw peanuts in the shell, and you have gasoline in the form of crude oil. Those sound so absurd because peanut butter is not raw peanuts.
Right.
Steam is not water, and gasoline is not oil. And yet, that's the interpretation the government uses when in fact the statute says gain derived from, not
right.
Gain in the form of.
Right, they are different. The gains from the income derived from salary, wages, and compensation for personal services. The income is something separate and apart from those three items.
So steam derived from water, peanut butter derived from peanuts, gasoline derived from crude oil.
Excellent examples.
And, well, they're basic. And so we jumped out of tax law, which can be difficult for a lot of people to understand. And you see it repeatedly in those historical references that you have in that document to law after law after law after law, from starting in 1919 right through the 30s, gain derived from, not gain in the form of. Those
Right.
are two different things. So historically, you're on the same page as Section 83.
Yeah, but here's my question to you. Hey, that's an excellent example that you came up with. Steam from water, or gasoline from oil. Those are real good examples, and that has a direct translation to what we're looking at in reference to statutory definitions. But let's deal with the water, the peanuts, and the oil. Would you agree that salaries is different from wages if the words are there?
Salary is different than being paid by the hour, but they're both compensation for services.
Okay, well, wait. How can they be if the sentence says salaries, wages, or compensation for personal services? Then compensation for personal services is different from salaries and wages. Would you agree?
It's not different. If you start in Section 61A, you fall into that trap. And what you have to do is start in Section 83, so you're never talking in Section 61A about anything other than the excess over the amount paid, whether it took the form of salary, compensation, or wages.
All right, here's the point I want to make. That when there's a difference in 1939, if you're dealing with the 1939 code, they dealt with net income as the basis for the tax. There's that concept there. You got to first determine net income, but then when you transition over into the Fitch-4 code, it's still the same thing, but there's a principle change. They were still dealing with the determination of taxable income under the 39 code. So the change that is made in the 54 code is, they ignored the whole concept of determining net income, and they just start off with taxable income. Well, that's what the whole tax code deals with, just taxable income. So there's a transition change from, the 39 code to the Fitch-4 code. And then when you take a look at, the statutory definition of gross income under the 39 code, which says gains, profits, and income derived from salaries, wages, and compensation for personal services. Then when you take a look at Section 61, which is what Congress says in its cross-reference table, Section 22 of the 39 code, which defines statutory gross income, when you take a look at that, it became Section 61 of the Fitch-4 code. It starts off with compensation for services, leaving out salaries and wages, and I maintain that there's a reason for that. Have you noticed that?
I've noticed it, but it's nothing that carries any weight with me because I know it all takes place after depriving me of Section 83. And so I'm really in this to prove not that I know everything about the tax code. I'm in this to prove that they're stealing so I can take the next step forward and address that fact.
Okay, good enough.
And all of their conduct regarding taxing the value of labor, understand, from the 1939 tax code on, takes place in defiance of the basis statute, which became Section 1012 of the 1954 tax code. So even though Section 83 didn't hit the books till 1969, it embodies the same calculation of cost that they always were to use, which is all property is a cost. And they've always acted in defiance of that standard. And when you think about it, if we got a cabal running the country that's so corrupt, do you think for one moment they forgot to corrupt the judiciary? And so judges are half of this problem. And so we don't have courts, and the judges have a million places to run inside the tax code, so you really have to narrow it down, and you make the claim, I've been deprived of Section 83, 212, 1001, 11, and 12.
Well, that's a real good strategy. That's we need more people thinking in terms of like that. Study the tax laws, then come up with a way of doing like exactly what you're doing, putting these guys on the offense. I mean, on the defense. You go on the offense.
Right, and the research is done. If you only studied what I teach, you'll end up in the same position, the same posture as I have, which, by the way, in March of 2006, somebody called me and said, I just heard your name from a friend of mine. I never heard of you before. What do you do? The IRS is really heating it up on me. I said, do you want to become a co-complainant to this complaint I filed in January of '06? And I showed him my findings, and he goes, this is great. I know everybody in the movement, and I know what they teach, and nobody's doing this. It looks really good, and I like your posture of offense. He joined my complaint. By summertime, they had turned it over to the Criminal Investigations Division of the IRS. So he served all of them with a copy of my findings and his affidavit. Then in fall, they turned it over to the DOJ for a grand jury, and he served all the local assistant U.S. attorneys and the DOJ with a copy of his paperwork. And by January of '07, he was to appear in front of a grand jury, and anybody similarly situated would have been indicted, but he went in there with this posture saying, you guys are the criminals. He even told the judge, you know, I served you with a criminal complaint, and here you are, you're willfully complicit in their conduct. And he says it would look like somebody had thrown cold water on her. And he never heard from the grand jury again. And now he's my promoter.
Right,
Chris Chapman. And on wevgov.com, you'll see at the top of the menu column on the left, YouTube and YouTube 2. Click on YouTube 2, and it'll take you to my Take from Caesar YouTube channel and take the seminars. If you don't, you know, if you read tax law and case law, your eyes will roll back in your head if you're not used to it. And so here's a couple of video seminars that you can take as I lead you through these provisions with verbal narration. So everything is on the web. And now I wanted to mention, if I could, an IRS publication they rewrote because of my attacks under Section 83.
Take off.
I'm telling you, this is Publication 17, the blue and white booklet they send to every household in America. And I'm looking at the 1993. This is when I first started litigation. I was using these as exhibits 5 times in the Supreme Court, so they rewrote it. But here it is, Part 14 of Publication 17 on page 117 of the publication. Basis of property is the name of the section of Publication 17, which is called the Tax Guide for Individuals. So this is it. This is what they want everybody to know. And here in the middle of the page it says cost basis in bold type, like 18 pick, and it says the basis of property you buy is usually its cost. The cost is the amount of cash and debt obligations you pay for it and the fair market value of other property or services you provide in the transaction. Your cost also includes, tell me they didn't just include in cost the value of my services.
Right.
And so I hammered them with it, saying right here in your own publication, my cost is the value of my services. In 1994, it says the same thing. And then in 1995, it had been rewritten to say this. Part 14 of Publication 17, 1995 version, page 115, cost basis. The basis of property you buy is usually its cost. The cost is the amount you pay in cash, debt obligations, or in other property. Your cost also includes. Tell me they didn't just quote, basically, Section Regulation 1.1012-1A that says your cost is cash or other property.
Well, yeah, they do that. I've seen the IRS respond to the arguments that are being made, and they do things like that in order to be less, to deprive you of an argument. Well, we no longer say that. Hey, folks, the music's come on. We still got another 30 minutes with David Myrland. Stay tuned. This is going to be education. He's Hammer and Anvil. Hey, David, before we get started, I want to give some homework to our listeners. I want to direct our listeners over to the Truth Tech Law Library, that same old file I was talking about, Primary Sources of Law, and you will see posted there searchable copies of the tax acts and the regulations. So for the 1916 Act, you had Regs 33. For the 1918 Act, you had Regs 45. 1921, you have Regs 62. They're all posted there. And you can download those copies of the regulations, their PDF images, and they're Word searchable. Now, I want to tell our listeners something that's real important. Don't think that those regulations can't be useful. They are. When the income tax was first enacted by Congress, and they delegated the Secretary of the Treasury and the Commissioner of the Internal Revenue the authority to administer and enforce that law. Well, the Commissioner of Internal Revenue had to have a uniform construction of the words that appeared in the tax laws. And you got to admit, compensation for personal services, which is something that David has been talking about during the course of this program. Compensation for personal service is a phrase that is used in the old tax acts and is still used today. Now, here is something I would like to have our listeners do. You can take those regulations. They're all there. Regs 103 for the 1939 Internal Revenue Code is posted there on the internet. You can download it. Why don't you find out what the Commissioner of Internal Revenue, he needed to have everybody in the Bureau of Internal Revenue have the same, meaning for all these words in the tax act. I mean, you can't come along and, if you're administering a law, have a whole bunch of different employees giving a different meaning to the act and the law that you're enforcing. So the commissioner came out with, here's my view about what compensation for personal services is. It's right there in the regulations. But it's different from what you might think that it is. Yet, there has been, a constant, description of what compensation for services is since the very beginning. And it would be very beneficial if our listeners would just simply download those regulations. Since they're word searchable, you can type in, don't use long phrases. When you're searching through a PDF image, you don't use long phrases to do your word searches. You can just do something like compensation. Do a search for that phrase. And then just study all the hits that you get back. There is something there, and I'm not going to tell you what it is. The reason why I don't tell people what it is, but I don't want people to be lazy. Too many people are lazy, and they're lazy when you sit there and just tell them what it is. That's not the way I operate. I want you to learn, and that means you will download the regulations and start looking. And then when you find a hit, boy, I think you will be surprised. The reason I know that is because I have previously done that. And then you ought to go try to find, Section 61 of the current Internal Revenue Code, the Internal Revenue Code of 1986, which is identical to the Section 61 of the 1954 Internal Revenue Code. If you take the current regulations and just start looking for what is compensation, the first thing that is described in Section 61 is compensation for services. And I've already told you that salaries and wages were dropped from the definition when you move from Section 22 of the 39 Code into Section 61 of the 54 Code. Suddenly salaries and wages vanishes from the definition of gross income. But then you're still left there with looking at compensation for services. Why in the world don't you find out what that is? Don't you think it might be surprising if you would find out what the IRS says is compensation for personal services? Now, David, I have just, I am now at the end of giving my instructions to our listeners, and hopefully, some of them will do what I had to say. So now that I've done that little task, let's get back to the task at hand. What do you think that Americans ought to be doing in reference to the income tax?
Okay, here's what I think they ought to be doing. Get a pen and pad, everybody. Every time you listen to me, I'll be citing statutes and regulations till the cows come home, and it's all about statute. And here's what I want you to do. Understand that I have products available at wevgov.com. You can save 10%, and you can pay the Micro Effect 10% to keep their doors open. It's a great service they provide. You don't get access to licensed attorneys. And to have Mr. Becraft on the radio, whether he has me on or not, is a magnificent opportunity, and I'd like to see the Micro Effect benefit from opening their doors to me. You go to my products page. If you're going to order a product, you click on Order, and a shopping cart page pops up. There's a promo code or a coupon code window. You first enter the word freedom, and then click on Update, and you'll see 10% come off the price that you have to pay, And with that, understand my office is going to give a commission to themicroeffect.com of 10% on the price as well, and we'll get those materials out for you. I urge you to start with the flash drive that contains 3 hours, 45 minutes of video, 7 different segments that I was teaching seminars here in 2003 to a small group of students here in Seattle. And what I can do to the tax code at a whiteboard will astonish you. I'm the only one that diagrams the tax code. I graduated from speaking in terminology and conceptual terminology about what is and is not income. I can show you the structure of the tax code, the way that it works, and the softest spots in the IRS's enforcement, meaning misenforcement. And I've narrowed it down to about, I don't know, I think the last count was like 40 provisions that explain most of the arguments where they're in the most, they're exposed the most by these arguments. There's a million things you'll find they do wrong.
All right, well, hey, David, let me stop you right there. You know, you said you got stuff on your website available, and you've given them directions. You know, now you kind of, I would like to know, describe each of the separate items. You know, you told us about a flash drive. What else?
There's a manual about Section 83 that I wrote in 1994. March of last year, I added a 30-page epilogue to it to bring it up to date. And in the back is the compilation of citizens arrest case law excerpts from upwards of 40 cases, I think. And that book is available. It's called Codebreaker, the Section 83 Equation. There's the flash drive. And I also have Take from Caesar, Volumes 1 and 2, which the first one is hard copy, perfect bound, which is my 2006 congressional complaint. The second volume is my August 27th, 2014 supplemental briefing to the complaint that went to Congress.
So those are in book form?
Yes.
Okay.
And it contains not only the supplemental briefing, but also my briefing of the Section 83 argument and another argument and void for vagueness for an appellate court, so you can actually see how I would take it into appeals on a circuit court. And I think I've got a guy that's going to be filing it. His deadline's in March, so I'm active on this. And when you get these, understand, these are briefings. I'm talking to judges with these documents. I'm talking to members of Congress with these documents. If you want to see a highly refined, elevated legal pleading style and ability, you'll see it in these documents. So those are all on the tax front. And I wanted to thank you for having me on the air very much, Larry. I very much appreciate it.
My pleasure.
And what I'd like to do is gravitate away from the all property is cost type of argument into my first and primary argument, should they even be talking to me about the tax code to begin with.
All right, well, hey, David, we got about 15 minutes left in the program. I just want to give you that warning, so take off.
Okay, great. Now, this is all on the federal income taxation page of wevgov.com, so I'm looking right at it right now, and the first argument is Social Security doesn't apply to Americans. Why would I want to do that? Because Social Security in Chapters 2, 21, and 23 have a common definition of, meaning the definition is in common among those chapters, the same citizen, and it expressly excludes citizens of the United States. And so I make the argument, I'm not subject to Social Security chapters, which leaves me with Chapter 1 of the tax code. But before we go there, you want to look closely at my description of this argument on the website. I say Chapters 2 and 21 apply only to that citizen of the possessions that are defined in statute, and it excludes me. And I got 7655 that says for taxes imposed on the possessions, see Chapters 2 and 21. Great, I'm halfway there. Then I've got a statute.
Well, a citizen of the possessions is one that is subject to the jurisdiction of the United States. That's why. But go ahead.
I don't even make that argument.
Oh, okay.
I just say this statute excludes me because I'm a citizen of the United States, and these chapters say expressly that I'm not included in the definition of definition of citizen. That's all. And then I go on to see 7651 parentheses 5A, which was amended in 2007 to be 7651 4A. And it says, for purposes of this section, the reference in Section 28A, the Revised Organic Act of the Virgin Islands, to any text specified by Section 3811 of the Internal Revenue Code shall be deemed to refer to taxes imposed by Chapters 2 and 21. 2 and 21 are Social Security. Those are my object. I'm looking for proof they don't apply to me, a citizen of the United States. And this statute says any reference in the Virgin Islands to a tax in Section 3811 really means Chapters 2 and 21. So
well, hey, let me stop you right there, David. You need to add one more thing to that, and that's Obamacare. Obamacare and Social Security.
No. But I don't add it at this juncture.
Yeah, I understand. I guess I was trying to make a joke.
I already wrote a course about Obamacare. Okay.
Okay.
It's not available yet. But anyway, I see the photograph of Section 3811 right there. That's equal to Chapters 2 and 21. And Section 3811 of the 1939 tax code says collection of taxes in Puerto Rico and the Virgin Islands. A, Puerto Rico. B, Virgin Islands. Then there's the definition of citizen from Title 42 where they dispense Social Security benefits. I'm not eligible. I'm a citizen of the United States. Then there's the Social Security Act of 1935, Section 211, and it excludes me again. Same definition of citizen. And so Social Security doesn't apply to me. Now I'm left with just Chapter 1, and I go to the statutory definition of citizen. I look in the index, the table of contents. I go through the whole Chapter 1. The statutory definition of citizen does not exist. And so they wrote a regulation saying citizens of the United States owe this tax.
It applies to individuals, does it not?
It could be the individual who's got that citizenship in Chapters 2 and 21. I'm telling you the argument that I make to get an indictment, to attack a grand jury proceeding. And so whether or not anything else figures into it, I'm not using it. So back to Chapter 1. There is no statutory definition of citizen, and they wrote a regulation, and on this page I've got the whole statute, Section 1, the whole thing right there, and nowhere does it mention anybody's citizenship. And then you got the regulation that does mention citizenship. You can't do that with a regulation. And my allegation is that if they hadn't written this regulation, it couldn't reasonably be applied to citizens of the United States like me, because it's just a regulation, and the 16th Amendment says Congress can lay and collect this tax. It has to be a statute. Then there's the cite of a quote out of 40 different cases where they rely on that regulation to say you owe the tax, and in none of those cases did anybody...
David, it's a citizen subject to the jurisdiction of the United States.
And I don't make that argument. I don't make the argument. I say I'm a citizen of the United States. Now, is statute constructed in a way to apply to me? No, it's just a regulation. And in none of these cases cited on that page does anybody take the time to go, excuse me, but that's just a regulation. Instead, they said, hey, I'm a non-resident alien. Go ahead and send me to prison.
All right. Hey, David, let me stop you right there. Give us your website again. What is it?
WeVGov.com. WeVGov. WeVGov.com.
Okay.
And it's all right. So back to this argument. I'm only named in a regulation if I'm the citizen they say I am. I'll be that citizen long enough to tell them, you've only implicated me through regulation. They can't talk about this argument. It should be easy enough to prove statute imposes a tax when I make the allegation that only regulation imposes it. And they can't. They needed a protective order in U.S. District Court, August 2005. Judge Lee Yeakel issued a protective order against this argument. If you've never heard anything as ridiculous in your life. And so if they need a protective order against this, I'm going to keep hammering that button until it falls off the control panel. You bet. And so arguments 1 and 2, I'm only named in a regulation in violation of the 16th Amendment, and furthermore, you deprive me of Section 83 when you tax my pay. You're a felon, you're a racketeer, everybody can arrest you. What were you thinking?
Well, hey, David, on your website, you have, I'm looking at it right now, you have a bunch of stuff that people can download just to simply learn about the arguments?
They're not downloads. They're actual web pages with all the information on them. And then I have products that you can purchase if you want to know more.
Okay. And this thing about the Social Security that you're talking about, is it on your website?
It's the first thing outlined on the federal income taxation page of wevgov.com.
All right.
I go to the left-hand side and I click on Federal Income Taxation page, and then I read about the arguments. I can go to my YouTube 2 link and take the seminar that's called Key to the Code, because this is the key to the code, whether or not it even applies to you.
All right.
You're only named in a regulation.
I know we've devoted a lot of this program to the income tax, but you're off into other types of issues. You said something about driving, not during the program,
Sure.
but in our phone calls. What are you into in that regard?
The big problem is big government. If government made less money, we'd have less government to deal with. And when I can prove a revenue stream is illegal, I'm going to go to my racketeering and extortion statutes and file criminal complaints, and I'm going to implicate the judge. And the only thing we're going to talk about in traffic court or tax court is when it would be convenient to arrest them, because they can't deny a thing. There's a state income taxation page that shows in the states that I've included laws from those states. I haven't gotten to every state yet, but that build upon the federal standard for calculating what is gross income. So on the state level, they're depriving of Section 83 as well. Then there's a motor vehicle code page. I found a phrase that's in the law everywhere from coast to coast in October of '05. It started with a Washington State 1961 Sessions law that said highway is any way, lane, street, road, boulevard, or other surface open as a matter of right to public vehicular travel. I said, damn, but that doesn't sound artful. No doubt because of all the Supreme Court case law I've read. And I typed that phrase into Google, open as a matter of right to public vehicular travel. I got 464,000 hits. I just clicked on the motor vehicle code page of wevgov.com, and right there at the top of the page, you see a paragraph that starts with this criminal complaint. But above that, you see search engine links. I'm going to click on Google. And on that phrase, I get basically 3 million hits on open as a matter of right to public vehicular travel, and the top hit is wevgov.com. So it's in the law everywhere from coast to coast, but especially here in Washington State. I found a gold mine of references, and so I wrote the brief that you'll see behind this criminal complaint and filed a racketeering and extortion complaint against all Washington authorities that are misenforcing the motor vehicle code, from the cop on the street to traffic court to the director of licensing and the governor, and filed it with Kurt Riggin as a co-complainant with the DOJ and Congress, and never heard a word back from them. And what people do is they file an affidavit of joinder against the cop, the judge, the prosecutor that's against them in the traffic case, join them as similarly situated criminals to this complaint, and then file it all under their motion to dismiss with a demand that the contested hearing include the police officer that issued the ticket so we can discuss public vehicular travel, which causes them, evidently, to tell the cop, don't appear at the hearing so we can dismiss the ticket. There's a course on how to do that in the products page. So you can
hey, David, we're almost at the end of the hour. What's your position on smart meters? I noticed you got a link here on smart meters.
There are conclusions that smart meters will cause bodily harm. And if If you believe that, and you got doctors' opinions and everything, and electrical engineers that have come out and said these are harmful, how is that not a conspiracy to commit first-degree assault?
Yeah.
Such a conspiracy is a felony, and if your city council, county council, whoever passes a law requiring smart meters, how are they not engaged in felonious conduct? If you think they are, go to the citizens arrest page, and you tell them, we can all arrest you now for your conspiracy against our health. So smart meters is not high on my radar, but that's my reasoning why I included it on this website. So there's a book called Public Vehicular Travel, America's Forgotten Right, that contains the complaint and memorandum filed with the DOJ and Congress in '06. Then there's a course that comes on flash drive on how, if you were so inclined, to file it comes in Microsoft Word, everybody. As easy as it gets. Everything's in Microsoft Word, and you can amend the motions to dismiss if you wanted to file them on your own. This is not legal advice. Into your traffic case to make this argument. Whether or not you win, you can't predict corruption. And so I'm not going to tell you you're going to win every traffic case.
But David, when people, you cannot just simply copy somebody else's work. The people have to understand it. Am I correct?
Yeah, and the course comes with 5 hours of audio instruction that takes you through the argument. So.
Well, hey, David, I want to thank you for being my guest this afternoon. We're almost just a few minutes away from the end of the program.
Been my privilege.
Hey, are we going to win this battle against abusive tyrannical government?
A whole bunch of butts have to leave the couch and get out there and pound the pavement.
Yeah.
You've got to get involved, everybody.
Sitting on their hands.
Yes, and they got to choose a cause, and they have to be the American. You got civic duty, like it or not. And the cost of freedom is eternal vigilance. Vigilance is not, oh, look, it's Beyonce.
Yeah, right. Well, hey,
my privilege, Larry, and thank you so much.
What words of wisdom have you got?
The law is perfect. I got protections all over. I'm in the box with all my arguments, which separates me entirely from everything in the quote-unquote movement. And if you just learn a few things, you can take a step forward instead of remaining in one place like the movement would have you do.
Right. Hey, folks, we're almost to the end of the program. I really want to remind you, go over to the Truth Attack website, go into the law library, hit that file called Primary Sources of Law, download and study the statutes at large. Hey, there's just a lot of people that don't know anything about the statutes at large. Why don't you at least take a look at it? Then while you're there, you can download the tax acts, you can download the regulations, and I would like to see some people, so why don't you find out what the commissioner said about wages? Who is subject to withholding, in the old acts? Has it changed? What in the world is compensation for services? Have you ever tried to make a determination as to what compensation for services is according to the commissioner today? Well, you can download all that stuff, and it's available there free for learning. So, David, I don't know whether the music's coming on. What final comment have you got?
I've made it as easy as it can get, and I've stayed entirely within the box under the canons of statutory interpretation, and I don't deviate from what judges have taught me in all these high-level cases I've read, and I have confidence in the law. The legislative branch has done its job federally and on the state level, and if you want to know whether or not they can overturn a gay marriage.
All right, hey, David, I'm going to have to interrupt you here. The music's come on. Let us know the inner program's arrived. You've been a great guest this afternoon. Hey, folks, be sure to listen to the great programs here on the Micro Effect Network, and be sure to come back next week. We're going to have another exciting program.
And there you have it. I hope you enjoyed today's interview. Be sure to check back here from time to time to the archives to see any updated episodes I might post. Go to wevgov.com and remember your coupon code for a 10% discount. My name is David Myrland. I'll see you in the next episode.
I say good show.